So we are talking today about modern day challenges and responsibilities of employers in this, ever-changing modern world that we're in. I say discussion because I am hoping that you will join me and that, I don't have to say things that are too provocative in order to inspire you to jump up and say something. But on the agenda, we'll be covering some of the more topical areas that we've been coming across certainly recently, but also obviously matters that have been in the media a lot. And first, obviously, we're going to be talking about office relationships on the sort of welcome side of the spectrum, and on the unwelcome side of the sex spectrum, the flip side of that is obviously sexual harassment. Now, in doing that, we'll look at how the courts have reacted to some of the changing community standards that we're coming across, as well as some of the reactions by employers out there, such as the AFL, where they dismissed two quite senior managers for having sexual relationships, essentially, with people who weren't their direct reports, but also weren't their wives. Now, when we talk about sexual harassment here, obviously, part of what we're talking about is the conduct itself, and there's obviously the legal claim that goes along with that, the sexual harassment claim that's prohibited under the Equal Opportunity Act or the Sex Discrimination Act at the federal level. Now, you also need to keep in mind that the problem is broader than just that potential, those potential claims, and out of the same sort of facts that gives you a sexual harassment claim, you might also expect a workplace bullying claim might arise. You might have people going away on workers' compensation. You might also have WorkSafe turning up at your workplace, investigating safety breaches. And you could also end up with dismissal-based claims. So there's a whole raft of liability that sort of stems from this conduct. But obviously, our focus, given the sort of time frame today, is going to be a little limited on that. So it's also not really possible to talk about sexual harassment without talking about reputation. The effects of the highly effective Me Too movement, and how things have played out in the media generally. In particular, I think one of the themes that I hope to bring out is that we continue to see this worrying trend of people being tried in the media, and the quite serious effects that this has on people, individuals and businesses, without ever going near a court. Now, I hope to also have time to cover domestic violence leave, which is just coming in. The Fair Work Commission has decided to introduce that in awards, so we'll talk about that a bit more later. And time permitting, we can also talk about some of the other social issues in this space that are coming up that any of the group want to raise. So I might hand over to Mr. McKinley.
Thanks, Ben. If you've been in HR for a while, no doubt you've had a situation where you've had to deal with an office relationship, or you've heard about it. If you haven't had to deal with it, or if you haven't heard about it, beware it's coming, because they are very common. The most recent statistics I could find is that 1 in 5 people meet their life partner or their spouse at work. And of course we know that the statistics are far higher than that for relationships that don't go the distance. Both potentially present problems depending on the circumstances, and the purpose of today is just to briefly touch on the potential issues that either married employees or just those that have a bit of a fling in the workplace present. And as Ben said before, feel free to interject, to ask questions, to throw forward your own stories of things you've seen or heard to get some discussion. So the question really is for employers, to what extent can you do anything about an office relationship? What are your rights to impose conditions or restrictions on what is effectively an employee's private life? A very pertinent quote. It was in different circumstances. This is a dismissal claim for 2 employees fighting out of work hours, but Vice President Ross, as his honour then was, says that employees don't have an unrestrained right to judge or discipline their employees' conduct outside hours, and employees are entitled to a private life, and I think we can all agree with that and wouldn't want to impose too far on that, but of course, as Ben said, there's some other considerations, and we'll get to them later. Apart from the highly publicised celebrities, most people's love life is their own business, it's private. And there's nothing unlawful about an employee being in a relationship with another employee or with a client or with a supplier, even if that employee is married. And again, going with Vice President Ross's quote, employees are not the guardian employers are not the guardian of its employees' morals. But where the employee is in a relationship with an employee or a client or a supplier, it can have negative consequences. It can certainly have legal ramifications, and in some circumstances it can be a disciplinary issue. And so there's competing interests in trying to manage office relationships. I'm going to talk about why we think you should set some boundaries, but first Ben is going to run the case for why we should let relationships slide.
Don't know whether I'd go that far, but as Ben's outlined, many people do develop relationships in the office, and who are we to stand in the way of these budding romances? The law recognises your right to a private personal life, at least to an extent. That's one of the areas we see developing in the law, is this sort of encroachment on, of work on people's private lives, and that divide. Both the courts and the Fair Work Commission recognise that employers are entitled to protect their interests more and more in areas that have been traditionally considered employee private lives. And Ben mentioned sort of the leading case on out of hours conduct in Rose and Telstra there. There's another one involving Telstra that you might have heard of, the Telstra sex romp case, as it was known by the tabloids, which involved, I think really illustrates sort of where we're going to, but also the protections that are there for employees, in that in that case, Carly Streeter, one of the employees at a Telstra shop, had gone to a Christmas party, and afterwards employees had arranged for a sort of an informal function to occur, whereby they all went round to, they booked a hotel room, and there was a party in the hotel room, mainly made up of employees. Now, Ms Streeter engaged in some sexual conduct in front of some of her colleagues. Some of those colleagues were upset, and they complained about it at work the next day. She was hauled in, and she was sacked on grounds of sexual harassment. Now, that was ultimately overturned by the Commission, and they said, look, you can't interfere with people's private lives in that way. But they upheld the dismissal because she'd lied about her conduct when they asked the questions. So you don't have to talk about it, but you certainly can't lie about it. And that's sort of the grey area that we find ourselves in. Now, the law also has specific protections in there for our would-be lovebirds, at least here in Victoria and also in Tasmania. The rest of the country doesn't have some of the strange anti-discrimination laws that we do. And one of the protected attributes we have down here is lawful sexual activity. You can't discriminate against someone on the basis of any lawful sexual activity. And by that, we're talking about people engaging in sexual relations of itself, as well as engaging with sexual relations with a particular person or persons. Now, there's, I suppose, no clear definition in the legislation about what lawful sexual activity is, but our Supreme Court has, given us some pretty clear guidance there in the case of Pearson and Martin. In that case, we had a former teacher, well, he was a teacher, sorry, who developed a sexual relationship with a former student. She was 18 years old. She'd just finished school at his school, and pretty soon after that happened, they moved in together. Now, her parents were a little upset. There were some suggestions that he'd been grooming her. Now, the school ended up terminating its employment and went to the Supreme Court, and the Supreme Court said, well, that decision that you made that he groomed her, that was coloured by the fact that they ended up in a relationship, and you really didn't have enough to get there, and so you've relied on the fact they're in this lawful sexual relationship and you've discriminated against them on that basis, and they awarded him $80,000. Now, I think in essence what they were saying there though is you were looking at what happened subsequently and allowing that to colour your judgment of what happened beforehand. But it is, I think, a controversial decision, and it's not to suggest that you cannot make rules to govern relationships, and certainly in another case in academia across the on the other side of Bass Strait in Tasmania, a university professor who had a relationship with one of his students was found to the university was justified in terminating his employment because he couldn't be dispassionate when assessing her, and that makes sense. We're steering into sort of classic conflict of interest territory there. Now, obviously, when I talk about setting rules, if you're setting rules, they need to be reasonable rules. So if you're trying to create a safe workplace, trying to stamp out sexual harassment, promote respectful interactions between staff, those sorts of things, notionally you can do, and you can set rules around that and discipline people if they breach those rules. But obviously it's a fine line if the reason you're disciplining someone is because they have engaged in lawful sexual conduct. So that needs to be managed really, really carefully. But while you mull that one over, I'll let Ben talk about the other side of the ledger.
Yeah, so there are two good reasons why you would consider not interfering, but we think the converse considerations are are pretty compelling as to why you should set parameters. And as you'll see, the why you should act list is far longer than the sit back, relax, and enjoy the show list. So, of that list, sexual harassment and reputational damage are the two most common, and they're really the ones that are likely to cause the biggest impact on your firm or your organisation. Go to the first one, sexual harassment, the key risk. We know what sexual harassment is: unwelcome conduct of a sexual nature, which would cause a reasonable person to feel offended, humiliated, or intimidated. Now, it's not sexual harassment if the sexual conduct is welcomed or invited or reciprocated. But that's often where things get tricky. So many allegations of sexual harassment arise after a consensual relationship ends and the connection between those two parties deteriorates. And last year and the year before, I think, it was a perfect example with Channel 7, Tim Warner and Amber Harrison, where there's a consensual relationship for 2 years. It goes south, and then there's some allegations, and I accept that Ms Harrison raised almost every allegation possible and every complaint known to man, but one of those was sexual harassment, and it went sour. Someone drew the line, and she alleged that Mr Warner continued on with his sexual harassment after she'd drawn the line. Now ultimately it's never been resolved with a settlement, but that's generally how these things come about.
Yeah, I certainly had a case myself once where I was acting for an accounting firm, and one of the partners, small accounting firm I should say, I don't think this would happen in larger accounting firms, but was sharing pornography with the receptionist. They would, engaged in this emailing pornographic images to one another. Now, she ultimately complained about that and raised a sexual harassment claim. That happened after her boyfriend saw the emails and she needed to explain them. But there wasn't a clear line drawn in that case, but it does affect, I suppose, also the other side. If you think about sexual harassment, you can draw a line as to when things are unwelcome, but whether objectively someone would be offended, humiliated, or otherwise upset by some of the images you're sending, might be judged by the lens of their past conduct.
Yeah, and so we'll talk about reputational damage later, but the damage that's caused by a sexual harassment complaint, even in circumstances where it is ultimately not substantiated or not proven, or in the case of Robert Doyle, is unable to be sort of progressed. The reputational damage is done at the start, and Ben will talk about that later with the Me Too campaign, and so it is a significant consideration. So as you'll know, the firm or your organisation can be vicariously liable for sexual harassment of its employees where there's a proximal link to the employment. And I'll give some examples later about how that can occur. It doesn't have to be during work hours and physically on the premises of your organisation. So sexual harassment, breach of duty. There's two things here. There's breach of the duty of fidelity and there's also a breach of confidence. So an employee's duty of fidelity requires him or her to act in good faith, faithfully, and to avoid situations where that person's interests conflict with the interests of your employer. And we know that managers are held to a higher standard and they've got a higher duty of fidelity. And so you can imagine the risk or the potential for a conflict of interest or a breach of the duty of fidelity to arise where a manager is in a relationship with a subordinate. And in 2015, the Fair Work Commission, in a dismissal case, which I'll get to later, there was a manager in a bank at Westpac who was in a relationship with a subordinate and gave her numerous pay rises and promotions which people felt were unwarranted. And the Fair Work Commission said it should be obvious to any reasonably intelligent person that for the manager to form a romantic relationship with a direct subordinate creates a potential for a conflict of interest. And I think it's pretty obvious. So compare that to what Ben was talking about before with discrimination. So you can't discriminate on the basis of lawful sexual activity. But there is that link, it's like in general protections claims, where you've got to sort of change what the reason is. Where there is that.
We're not changing the reason, it's the true reason, the true reason.
They know what I mean. The reason is not that they're engaging in lawful sexual activity, it's the potential, it doesn't have to be actual, it's the potential for the conflict of interest. Now the breach of duty of fidelity might also arise where an employee is in a relationship with a client or a supplier, and you can imagine, people in relationships do talk, and sometimes work comes up and you might say something that you shouldn't. You can imagine the commercial advantage that a client or a supplier might get in circumstances where some confidential information, even if it's inadvertently discussed, gets disseminated. And so that is potentially a breach of fidelity, the duty of fidelity, but also a breach of confidence. And the other interesting situation where a breach of confidence comes up is where there's two employees. And in Australia there's no right to privacy, but we're seeing more and more that there's this breach of confidence that is filling the void for the right to privacy. So take the example where two employees are in a relationship and they share intimate details and pictures of each other. The relationship breaks down and then there's some dissemination or there's a threat of a dissemination of those pictures or of that detail. I mean, does anyone have a view on whether that can be stopped, whether it's compensable, or if it's, look, that's bad luck, you shouldn't have done it in the first place?
No one's had to deal with that before?
Well, that's a good thing. So there is a case I'll talk about later where there's an injunction and compensation given to stop a jilted ex-lover sending on the images. So that's a good thing for some people. Now, workers' comp is also a consideration. It's a no-fault scheme, obviously, but it does have an impact on your insurance premium. And the two final considerations, reputational damage and organisational culture, they're not legal risks per se, but they're worth considering in determining what decision you're going to make if an office relationship arises, or if you're going to be proactive about it, what to do about it. And as Ben will explain later, reputational damage, and he's mentioned the AFL. So you look at that situation with the AFL and Simon Lethlean and Richard Simkus. Now, those relationships were, as far as we know, entirely consensual. They're not with anyone within the management stream of either Lethlean or Simkus. And yet the AFL and Lethlean got really hauled over the coals for it. And you sort of look at the reasons why. I mean, as employment lawyers, we say, well, what's the risk there? Why is Lethlean, who's very highly paid and very good at his job, why are they dismissing him? Is there something else? But I think it was just the reputational damage, or the potential reputational damage that the AFL might suffer by having this relationship continue, especially where Letters and Simkus were married. So there's that reputational damage, and you look at Channel 7 and how that's all been sort of played out through the media with Tim Warner and Amber Harris, and no one really comes out smelling like roses in a situation like that. And the culture of organisations, I'm sure it's a huge focus. It's certainly, not being in HR, it seems to be a huge focus now about the culture of an organisation. You want to hire and retain good people, and you want to create an environment which, in which people want to come to work, people feel comfortable, people feel like it's a trusting and fun environment. That can often be eroded in situations where there's an office relationship. And if I can just be a little bit self-indulgent, I'll tell a story about a past life. I was at a previous employer. It was a footy club, and there was a lady there who was, a bit of a confidant for the boys in a very male-dominated environment. It was nice to have someone to speak to who wasn't one of the players or wasn't one of the coaches. And someone that you thought was, a little bit separated from the coaches, and so you could be pretty honest about what was going on. And she started having a relationship with one of the more senior coaches, and the relationship between the players and her really deteriorated because, it didn't for the start, and then all of a sudden, the coach relayed back to you something you only told her. And the lack of trust was really, really damaging for the playing group and for the coaching group. And whether this had a full impact or not, the team really suffered. We were no good for a while. And I think it just sort of damaged the fabric of the organisation. And so that's potentially one of the things that if you're trying to create good culture, that may, it doesn't always, it doesn't have to, but it may be something that just eats away at that, especially if it's a pretty tight-knit team or if it's a smaller organisation. So just something to consider. So I go through some case examples. Obviously these aren't the full gamut of cases in this area. There are quite a few of them, but just some which highlight some different areas of where the risk is and what we're talking about. Hopefully join the dots a little bit. So in Lee and Smith, the employer was vicariously liable for sexual harassment and sexual assault. There were two employees. They were at a dinner party at another employee's house, and that's where the assault occurred. And the court found that due to a previous pattern of sexual harassment that was condoned or at least not pulled up in work hours, the employer was vicariously liable. I mean, it seems a bit tough, but that's sort of what came out of that decision. In the South Pacific decision, there was sexual harassment. That was a resorts, hotels. The employer was again vicariously liable for sexual harassment of the employee. Where it occurred outside of work hours, it was on a common premises, common accommodation, and the court said the reason they were at the accommodation was that it was a common purpose of their employment, and so the employer was found to be vicariously liable for the sexual harassment. In the Comcare case, it's a pretty highly publicised one. The High Court ultimately found the injuries that were sustained by the employee whilst engaging in intercourse with a friend on a work trip wasn't compensable, but you look at the first two decisions and you think about those and you say, well, what would the situation be if there were two employees who were injured in the course of intercourse on a work trip where the employer has paid for a room or has given them one room or has said you stay at the same place. In Comcare, it was an employee and just a non-employee, but you think about what would happen if there were two employees, and I think it would be compensable. Wilson and Ferguson, this is the one I was talking about before about the breach of confidence. So two employees, the same company in a relationship. Ferguson posted nude photos and videos on Facebook of Wilson after the employment ended. And Wilson sought an injunction and compensation and was ultimately awarded $50,000 in compensation, $35,000 of which was for non-economic loss, so hurt, humiliation, distress, embarrassment.
And he was obviously out to cause that too. I mean, he sent her a message that said, "I look forward to seeing you fold as a human being." You know, this was a very unpleasant individual and a nasty breakup, but these things happen. Hopefully not in our industry, you'd hope, but...
And it wouldn't have to be that, no, I mean that was pretty vindictive, but it wouldn't have to be that nasty for certainly the award of damages. There were no aggravated damages, so, you know, potentially that high, even where there isn't that sort of vindictive nature. And then the Westpac case is the one I talked about before, about the manager and the subordinate in the relationship, pay rises, which everyone thought was unwarranted, and promotions, and ultimately the manager was summarily dismissed, and the Fair Work Commission said that was fine. So there's some examples. There's plenty more, but Ben's going to talk to you about what you can do.
So, I mean, obviously one of the big problems with sexual harassment and, you know, these sorts of, you know, sexual conduct between employees and other people connected to the workplace is employers often end up having to pick up the bill. It would be better if you didn't have to pick up that bill when it all falls apart. So, and I suppose one of the key issues in the modern age is the size of that bill, because the courts have recently looked at the sort of awards people are getting for sexual harassment and, you know, other similar claims, things like bullying, and they've said, well, that's out of step with community standards. We're going to increase that and make sure it's aligned with community standards. So they increase, you know, for moderate level sexual harassment, you used to be looking at about $20,000 maximum was all you had to worry about. They said 10 times that's probably appropriate, so $200,000. So, I mean, that's a significant increase. Now, you'd think that that might have opened the floodgates a bit, because suddenly it was worth your while as a plaintiff to actually incur some litigation costs to get some real damages to compensate you, but that hasn't been the case. And you've got to ask yourself, why not? I mean, the Federal Sex Discrimination Commission has recorded in the last quarter with, you know, the whole Me Too thing, a 13% increase in claims, but proportionally, I don't think that's, you know, a very large amount considering the size of the problem that's out there. Now, it's certainly, I think, one thing to say in, you know, the relative anonymity of social media that something's happened to you, but I think there's, you know, the traditional barriers to people bringing these claims are still out there, and I think they're largely that they fear the repercussions. Even though there are specific laws out there to address it, people are concerned about what impact this is going to have on their career if they bring it up. Now, assuming that someone does go to the stage of making a claim of some sort, how do you avoid vicarious liability for, you know, the rogues in your organisation who do the wrong thing? So the law says it's possible. The catch is, I suppose, that you've got to have done all reasonable things possible to have stopped it. Now, that's a very difficult hurdle to meet. I can count the number of cases on one hand in which they've been able to do it. By way of illustration, I think all of the cases illustrate that what you need primarily is a policy preventing sexual harassment. That's your first step. That's base level entry. Then you had that same case I mentioned before that increased the damages awards to reflect community standards, which is Oracle and Richardson. You don't know it. It's an important case to be across, because in that case, the judge found that the employer could not have taken all reasonable steps to prevent sexual harassment because the policy that they had in place didn't do three things. So it failed to state in clear terms that sexual harassment was against the law. It failed to identify the source of that legal requirement. So we're talking about specifying the actual name of the legislation itself. And then it failed to state explicitly that the employer might be vicariously liable for that conduct. Now, to me, this sounds bizarrely prescriptive, and I think, you know, there wasn't a policy out there at the time that covered off on those three things, so everyone was exposed. Now, but the judge held that these three elements were essential to demonstrate, to bring to the attention of employees the consequences of a breach of policy and to demonstrate the lively and real interest that an employer will have in scrupulous adherence to its warnings. Okay, now, it's not clear that other judges will follow that decision in every circumstance, but I think it's a very brave person who would take the risk of not having a policy that addresses those three things. But you then, obviously, that's, again, still, once you're there, that's the base level. And the cases have gone on and shown that having policies, even policies that do the right thing like that, aren't enough. You have to embed the policy in your organisation's culture. So one of the things that you need to do is make sure that employees are regularly trained on the subject, that they're aware of their obligations, they're reminded about the policies at regular intervals, that there are transparent enforcement mechanisms and support that support reporting and reaction by the employer, and that you sort of proactively and consistently enforcing it. Now, those things ultimately affect the culture of the organisation, which is where you want to be. And in the end, if you've got a culture of respect, that'll go a long way to addressing some of the other issues that we've talked about earlier. Now, appreciate some of you might not be convinced. You might still be thinking about some of those other things that Ben said to you earlier. And what are you going to do if someone starts dating one of their direct reports? And this is a classic photo from the Herald Sun up there, but take me to the next one. Obviously, that is at the sort of the extreme end of your options, and there are a range of things you can do before you get there, probably starting on the left-hand side, where you can do nothing. That is an appropriate option that you might want to take. You might want to do nothing. The Fair Work Commission has said that, the fact that a conflict of interest might arise is a no-brainer. If your managers aren't doing something about that, then maybe you're already on solid ground to terminate them. You don't have to worry too much about that. You can just say, terminate them on the grounds of the conflict of interest if it arises. If you want to go a little further, you can require people to disclose the relationship. So, knowing that it's happening allows you to manage it. And certainly, we've seen that in the media with QBE's chief executive, John Neal. He made headlines after he failed to disclose a relationship with his PA to the board. And as a result, they docked his bonus by $550,000. So, I think he noticed that. Maybe not. But I've also obviously covered off at basic level workplace policies and training. In addition to doing that on sexual harassment, maybe you want to do it on, introduce some procedures around office relationships, how conflicts will be managed in your organisation, what you need to do about reporting, those sorts of things, how the organisation is going to address it. If you want to take it further than that, maybe you want to go to the level of prohibiting relationships between people and managers and their direct reports. Or do we go even further still? Do we introduce the full bonk ban? Now, I realise, a lot of you work in HR and law firms, so you already struggle in your daily life trying to make lawyers seem like nice people. This might be, taking it a step too far. Now,
Ben, can I make an observation about that?
Yeah.
In my firm, we've just recently gone to prohibition on relationships between direct support. And that's partly because when it comes to salary discussions and promotion of these people, it becomes very awkward for typically the partner to be in the room discussing these people. They have to excuse themselves, and to avoid that, it's much easier to change those reporting elements. Obviously, with the consent of the individual, who is usually the subordinate, being a lawyer, or sometimes even business services people. So, yeah, and it's literally free. So I work at Memphis Freehill, so we look at the news. And
we noticed.
Google that later if you missed that article. And that has just been recent. So typically it was unsigned, it was silent, but people would disclose. There's been obviously problems in the past where relationships between partners and lawyers haven't been disclosed and caused problems with the culture.
Yeah.
So
And I
that's the part where, you know, I hear what you say about required disclosure of relationships, but yeah, it's the...
Well, without that clear line, people might not know why they're disclosing, and they might not think it falls within the standard remit of conflict of interest. So I can understand why you take that approach and why you might want to set that, you know, quite strong boundary, particularly in a larger firm like HSF, where there's the potential in larger practice groups to move people around into other areas. Absolutely. Yeah. All right. Shall we move on to the Me Too effect? So, I mean, I don't think it's possible to have one of these discussions without talking about reputation and this particular movement. Now, this hashtag gained its present notoriety in about October last year and went on to become the Time Person of the Year of 2017. It all started when this young lady here posted a tweet that said, if all women who have been sexually harassed or assaulted wrote "Me Too" as a status, we might give people a sense of the magnitude of the problem. Well, I think people have a sense of the magnitude of the problem now. This post went viral, and you had 500,000 people responding to her tweet within the first 24 hours. That's just on Twitter. You then look at Facebook and posts and comments then using the term "Me Too." The number of those was 12 million in that same 24-hour period. It's a huge reaction. So, obviously, the Me Too movement kicks off, and we start seeing some heads rolling. And, there are a lot of sexual misconduct allegations that come out by those emboldened by the campaign. And, for instance, we see Kevin Spacey is digitally edited out of one of his films and he's removed from House of Cards. Now, that all happens without him going anywhere near a courtroom. As far as I'm aware, there was no legal proceedings involved in any of that, no investigation. Now, he may have copped to some of that in some of his comments, but, I don't see his career going anywhere. I checked last night on Wikipedia, there's nothing coming up. That highlights, I think, one of the more concerning aspects of the movement is that, some of the unchecked damage that it can do without the usual checks on justice that we have in our legal system. Now, you might say, suck it up, they're sexual harassers, they deserve what they get, but, what happens when it's an innocent person? I suppose the second issue that I see as being, not necessarily that desirable is its primary effect has been in sort of the celebrity area. In, dare I say it, the less sexy areas where, its effect has been less significant. It's not really touching some of the smaller businesses out there so much. Safe to say it's giving confidence to people to come forward. But, I think this is part of an existing problem that we have. It's just the nature of, it's a practical issue and the nature of the world we live in, that industries, or particularly brands that are household names, have always been vulnerable to sex scandals and, where their reputation can affect consumer sentiment. And so other less well-known businesses don't have so much of a problem there. So, if you think about David Jones and Christy Fraser-Kirk, for instance, that was, big news in the day. And in that case, Harmers, a law firm that specialises in using media strategy in their litigation, were able to essentially extort David Jones to pay far more money than you would ever get even under today's, increased sexual harassment damages, in order for David Jones to just make it quietly go away and protect its reputation. Now, where do law firms sit on this spectrum, I suppose, in relation to vulnerability? That probably turns on the firm, but in my experience, and I've acted for a few firms out there, law firms are generally eager to avoid both court and media attention. I don't know many of you who would be saying to the partners that you work with, no, let's run this the whole way. Now, I mean, certainly there have been a number of recent sexual harassment allegations in the professional services area. We've seen some people depart under clouds from EY and KPMG. And then my friend at HSF gave us the gift of Peter Paradise. For those of you who didn't see that, I don't know how you missed it. Did attract quite a bit of attention. I think that, you know, I appreciate you might not want to comment about that, but I do think that sent a very clear message about HSF's cultural position, where they stand in relation to that issue. But, I mean, it also effectively ended the career of this fellow. I don't think he was going to a competitor anytime soon. But, I mean, part of the thing about that was I think the broader message was sending to quite powerful partners that they are not protected species and they can't just do what they want. So, you know, I think that was good in that regard. Now, you might ask, are these sorts of results just? Do we need to be concerned about the capacity for, you know, people to be effectively executed in public like this? You know, and I must confess, as a lawyer, it makes me a little uneasy. And, you know, what do you do if these sorts of accusations are levelled at you personally or your organisation? I personally like to think, what would Geoffrey Rush do? And so the answer to that is, when allegations like that were made against him, he threatened defamation proceedings, which is the standard protection you've got at law. Now, it's a bit easier for Geoffrey Rush to do than a lot of other people to do, but those sorts of legal responses combined with a media strategy can be very effective. You know, and, you know, if you need to get the truth and your side of the story out there, that can be the way to go. Of course, if truth isn't going to work for you, you might want to ask, what would Donald Trump do? But look, on a more serious note, if you face proceedings, you do need to make a call early as to what you're going to do and whether you're going to try and resolve it quietly, whether you want to send a message, as our friends at HSF did, or, you know, I think one of the worst things you can do is set out with the view of fighting a thing and then settle later. Certainly that didn't work out very well for Clayton Utes when one of their junior employment lawyers made claims of sexual harassment. They firstly represented themselves, went on for a bit, got trashed in the media and then folded pretty quickly. None of that looked good for them in circumstances where, well, I have some inside information about that one, and, you know. Anyway, I want to allow us some time to talk about domestic violence leave, so I might hand over to Ben.
So we changed tack a little bit. The full bench of the Fair Work Commission recently made a decision that domestic violence leave would be included into all bar 2 modern awards. I think last week there was going to be a decision about the other 2. And in making its decision, it relied on some submissions and reports. It said 1 in 4 women in Australia have experienced domestic and family violence, and in a stunning statistic, 1 woman a week in Australia is killed by a partner or former partner. And so I think that really had quite an effect. And you know, all you need to do is watch the news. Certainly recently in the alleged murder-suicide in Margaret River in Western Australia, just to realise how prevalent domestic violence is. So in making its decision, the full bench found that domestic and family violence has a significant adverse impact, not only on those who experience it, but also on other employees and on the employer. And it's a community issue which requires a community response, and it said a special response. It resisted the urge to implement paid leave, although that's an issue that will be resolved potentially in another 3 years' time when they come back to it. They also resisted the urge to grant indefinite days leave, and so what they came up with was 5 days unpaid leave per year, which is available to all employees regardless of status, so permanent and casual, part-time. Everyone gets the same. It doesn't accrue, it's given at the start of the year, it's granted at the start of the year, but it doesn't roll over, so it's 5 days each year. And it's available to an employee, and it says down the bottom, who needs to do something to deal with the impact of family and domestic violence. It's impractical for them to do it outside of ordinary hours of work. Now, it's quite a wide definition, and Ben will talk about some of the potential impacts that will have. But it's, there's a definition of what family and domestic violence is. But it will be interesting, and even the Commission commented on how this is actually going to be used. At the moment, there's quite an unknown about, there's a big issue out there. We're not really sure who's responsible for it. We're not really sure how to prevent it, but let's see how this goes. And so there is this will be put into all but 2 modern awards and reviewed in 3 years' time to see, is this doing enough? Is there any reason for it? Do we need to make it paid and put the onus a little bit onto employers? So there's a few unresolved questions. The finer details haven't been ironed out yet, but I think certainly it's a step in the right direction for this process.
I know, just looking at that, I don't know what you're all thinking, but I'm just wondering, immediately jumps out at me is, what are the evidence requirements in relation to this? Currently, we're only talking about an entitlement for employees who are award covered. For all of you, we're going to be talking about really the legal services award, so that takes you to sort of secretary, paralegal, we've seen some companies have already introduced these sorts of policies. They have them they have it as a policy, or some of them have even made it part of their enterprise agreement, so it's become, essentially the award for their business. They've got in early and done that. One of the things I suppose you might want to consider is whether you want to get ahead of the pack and try and introduce it more broadly within your organisation. Both sides of politics have said that they're going to be bringing it in more broadly, so it's coming whether you like it or not. I think last year Bill Shorten was saying he was going to bring in 10 days of paid leave. He was just prepared to jump in at that level. Labor's cooled on that position now, and they're only talking about 5 days of paid leave, whereas
We offer 10 days paid leave.
you offer 10 days paid leave, do you? Oh, well, I'll ask you some of my other questions then about, has that opened the floodgates? Because I suppose if you're offering unpaid leave, there's not a huge potential for abuse. Now, I don't think that, it's obviously, you want to be supportive in these situations, and, there's going to be questions about what sort of evidence you do ask for and how do you prove these things. And I think a lot of people, if someone comes to them and says this sort of thing, they're prepared to take them at their word and just support them. So, how big an issue will it actually be? I don't know. But I mean, you can certainly envisage a scenario where someone returns to their abusive partner and they're taking domestic violence leave in respect of the same partner year on year. That's a possibility, but as far as we can see now that, the law will cover that situation and you'll be protected. If you did want to introduce it, and I'm interested in hearing more about Leander's example and how that's worked. Do you want to tell us a bit?
We've had it in place for 2 years now, and it's 2 weeks and 10 days of paid leave. We've only had one employee take it, which is enough to bring documentation. They're long-term employees and should feel weird to us. But essentially, there's only been one person taken in the last 2 years.
But I would think it's a scenario where people would take to get the hours, is something that is so personal, and for them to come forward and actually think there's something going on outside of work is impacting them. I would have no doubt that there would be instances that are going on right now that we wouldn't need to know about, that would explain a lot of certain behavioural patterns of people, and they would never come forward and we wouldn't behave those. So I think it is something that is so personal, so sensitive that I personally, in my experience, have not seen anyone take advantage of it or abuse. Particularly on the other hand.
That's part of the course.
Well, there's just speaking to designs from the Workplace and Equality Agency about paid leave for domestic violence family situations, which he said that there's a bit of a trend now that in this leave for people to take a lot more of it.
Yeah.
But not in the pregnancy.
Yeah, and I think it depends.
Yeah.
We certainly have paid leave as well, but in a situation where somebody, they've only had it for 6 months as well, but in a situation where it was more than what we were officially paying, we would let that roll. So yes, there have to be some limits to it at some point, but certainly if somebody was brave enough to come forward and we would welcome them to do that. It's a case by case basis.
Yeah. I mean, I suspect people might be dealing with these things without having to confront the embarrassment of necessarily talking about their personal life with their employer, and be taking other forms of leave to address this. You know, I need to take some urgent sick leave. Maybe they just tell someone who works immediately with them, and that's as far as it goes. But I mean, so yeah, yeah.
More people will use that. You've got to quite specifically say that it is for the specific purpose to
Yeah. Yeah. Okay. So, did you do that by way of policies, or it's just a policy? I mean, I think policy is probably the best way to do it. To allows you flexibility to change it if you need to when the laws come in, and you can adapt to them. I mean, one of the other things that, looking to the future, a big question out there on the horizon is what other sort of community issues are we going to see legislated and turned into leave entitlements for people? And look, I don't know if any of you have any ideas about any of that, but it's certainly something to look out for. But I've been given the sign that we need to start wrapping up, so you can all get back to it. But unless any of you have anything else or want to stay back, talk to us, or raise anything now.